4 and 5. Is your speaker on? This is very good. 4 and 5. Okay. Consent of the respondents, this and the S L. Sorry. And the counsel appearing on behalf of the DAGI. Place for adjournment. There is allowed. Placed after 3 weeks. Okay. Any interim order is there? No. Okay.
May I please, Lordship?
Yes.
Lordship, I would like to mention item number 18 with the concept of board supervision.
18. You taking consent?
Yes, Lordship. I require to file affidavit, Lordship.
You are for?
I am for additional, Lordship.
Okay. Consent of the other side, and counsel for the appellate. Place for adjournment. There is allowed. List after
3 weeks, sir.
3 weeks.
Of that.
Old habits did not go. Old habit of writing and sitting in the examination did not go. No. Yes.
Item 17.
17. Mr. Mandal is there. You are for appellant. 17. Okay. The prayer made by legal counsel for the appellant in arrest and respond today. This after 3 weeks. 3 weeks. Yes.
Please, Lordship. Lordship, I would like to mention item number 20 of the supplementary.
Instruction which 313 to be considered. Which 313 needs.
Oh, yes. But that instructions is not there.
Lordship, instructions need to be taken from the applicant. We are not taken to
That's
Lordship.
okay.
This is on Wednesday.
This one, 8/2023. As paid for by land council to the appellant. President General and APT is present. Yes. Yes. In this, I think this is coming from motion. I have to issue a notice. No, caveat may be there, but notice has to be issued here. Otherwise, it comes in motion for disposal. That disposal at motion stage, I am not inclined. Caveat is already discharged. To it. This is Sikya Leonard, counsel for the petitioners, and Mr. S. Nath Leonard, counsel for the respondent. With regard to the order dated 2/8/2023, the court is inclined to issue notice of motion returnable on how much time? Returnable in 4 weeks. You have received copies?
Right.
Without requiring the petitioner to take steps, as the respondent also has already entered the appearance. Affidavit by the respondent will be filed at least 2 days prior to the next requesting, based up to 2 weeks.
Right.
Okay, entry order past 2 years and extended to the next requesting. Just after that, it will be last. Yes, Mr. Chakravarti. You have any reply? But Mr. Chaudhary, in this matter, I think the point raised has to be heard. It cannot be.
Because idea of this decision has not yet been.
I tried to see that, but I did not. You appear to be right, but it depends on what Mr. Chaudhary says.
In this much case, my lord, you want to find a paragraph 14, my lord. One case has been defined. It is similar to the present case. Rambabu Bonaparte.
Shambhavu Verma. Which paragraph?
Paragraph 14, my lord.
It does not deal with that pension rules.
In that case, my lord, you were entitled to a state 330 to 4.
That's okay, but you see, the issue is that now TCC committee has taken the plea of statutory plea that was never considered earlier. So the ratio must be read in the context in which the facts are decided.
My lord, in this case, my lord, matter was summarized, my lord, and guideline was issued, my lord, last.
No, that may be. But does it change the nature of, you see, it does not make the nature of challenge of the, what you call, infructuous. There is a statutory plea.
Guidelines, yes, okay.
We'll issue notice. We'll try to dispose it of at the admission stage. Because Mr. Chaudhary, this judgment we have seen, what you call the Shyambabu. Shyambabu also doesn't deal with that pension rules. So recovery of money divorce the rules. Rafiq Pasi, I can understand. But once they are invoking the pension rules, then perhaps we don't have an answer. We can't say that on facts it's similar. Facts become dissimilar. Then principle of stare decisis may not be applicable. That's for you to argue now. For Mr. B. Chakravarti, learned CCC appearing for the petitioners, as well as Mr. A.H.M.R. Chaudhary, learned counsel for the respondent. On the ground that the respondent was wrongly given the benefit of third MACP benefit, sorry, benefit of third MACP. This for how many months? It was given in 2015, 15. By order dated 31/3/2015, on which date the petitioner was stated to have not been entitled to the said benefit, and therefore, by order dated 17/9/2018, the third MSC benefit given to the respondent was withdrawn, and he was granted the said benefit from 18 to 2018. Accordingly, the petitioners invoked the provision of Rule 71 of the CCS within bracket pension bracket close rules 1972,
is not specifically reflected in the.
It's not there in the order. Oh, acha, okay. Therefore, so therefore, no, don't write the rules. And accordingly, the petitioners sought to recall the benefit, the financial benefit granted to the respondent for the period between 1/4/2015 TO2 18 to 2018. I'm sorry, it will be 17 to 2018. Next one. Agreed by the said action of the authorities, the petitioner, that approves the Central Administrative Tribunal, Guwahati Bench, Guwahati, by filing OA number 040/106/2020, which was allowed by the impugned order dated 21/3/2023. The said order is under challenge in this petition filed under Article 226 of the Constitution of India. Next paragraph. The admission of this writ petition is opposed by the learned counsel for the respondent by placing reliance on the case of State of Punjab versus Rafiq Masih, within bracket Whitewasher and others, 2015, 4 SCC 334, and Shyambabu Verma, SHYAM, BABU, BERL, versus Union of India and others, 1994, 2 SCC 521. In this petition, the petitioner has taken a plea. Petitioners have taken a plea that under the provisions of Rule 71 of the CCS, within bracket pension, bracket close rules, 1972, the petitioners are empowered to realize excess payment made to the respondent. It is submitted that the cases cited by the learned counsel for the respondent is distinguishable from facts because in those judgments, the provision of Rule 71 of the 1972 rules was not considered. And accordingly, it is submitted that the ratio of the said the cited cases cannot be applied in the present distinguishable facts of this case. Next. Issue notice returnable on when returnable in 2 weeks. You visit extra copies. You have received a copy without requiring the petitioner to take the steps as the respondent is already entered the appearance. Affidavit you need to file at least 2 days prior to the mutual instance. List after 2 weeks. Giving you back this. This is after 2 weeks. Next week will be some difficulty.
Because there was no instruction from
Mr. B. Chakravarti, CEC. 24 and 22, it's time to file additional evidence to bring on record additional facts on which additional materials on which he intends to rely. List after 2 years. Yes, Mrs. Bordolo, your matter now. Yes, Mrs. Bordolo, your matter. We should notice this is the first. This is for the first time. Legal aid counsel. Okay. Mrs. P.V. Bordolo, legal aid counsel for the appellants and Ms. Jahan and the of the state. GLP 374 to read with 383 CRPC. Admit copy of the records. You should notice return to the respondent 2 returnable in 4 weeks. The traditional shall take steps for service of notice and respondent 2 by within 2 days by registered post to daily as well as the usual process, which will be served through the jurisdiction magistrate. This will go through you or it will go through registry?
If it is POCSO,
I have not seen
not a POCSO matter, then registry will send it.
registry. List of documents.
Then registry will serve it.
Okay. Okay. What is the issue?
Mine is not working out.
The voice is low. Seven, Mr. Kotaki. You admit it? Yes. Cover records. No notice is required. It will be, there's no private respondent here. Mr. P. Kotaki. For the petitioner. Mr. Jahan for the ADP. See over here, there is no private respondent. No notice. After 4 weeks. I on the receipt of the LCR. There's an IA should be considered on receipt of the LCR.
I'll file my objection in the meeting.
Objection to be filed by the non-ethical engineering. This 11 solved responsible condition of item 8. Yes, item 8. Answer notice. Address is left away. Then you have to ascertain the correct address. No, if she is left, she won't be found. Even the office address, it is shown as left. You have to ascertain the correct address. No. First you should know what is the address. Then you will take steps. What is the address? No, that is why you should have a habit of reading the record. Here it says the address is left. I am telling you for the third time the address is left, and you are not understanding. You are saying that you will take first steps. Can you take first steps on an address which is not there? Will it help you?
I will take instruction.
Huh. If it helps you to spend money, it's okay. We encourage you. But try to understand what I'm saying. Your name, Mr. D. Chityan, I'm counsel to the applicant, is informed that has been informed that the process sent by registered post with AD has been returned with postal remark addressee left, which is as per office note dated 22/8/2023. So accordingly, next the applicant shall ascertain the correct address of the respondent. And inform the court. When do you want matter to be listed again? List of 2 weeks.
Item 9.
You know what has happened is, here, I have a little problem here. Here, what had happened is on the last occasion, the order was that I'll serve notice.
No, if it is of 2022, you will have a lot of problems, not only one problem. Yes.
I mean, I was supposed to take fresh steps for notice upon respond number 2. It's a POCSO matter. Now I have taken steps. I have sent it to the OC through my office. I've sent a copy along with a letter. That report is not received as of date.
You send a reminder, we'll take it up next week. You send it by VHF.
No, what had happened is the office note is that I have not taken steps. Now, the requirement under the judgment is that they will take steps, give copy to the registry will send it back.
Yes.
Of course, that stipulation is not there on the last occasion in the order. So I have taken on my own, sending it to the office to the OC.
So we'll take it up next week. In the meantime, you get a report from your OC. Yes.
It's delayed. I know it's delayed.
Since January, we are taking steps.
No. You see now there's a division bench judgment of this court. There is a specific requirement that in these matters, especially on these matters, it will be the APP to take steps. So what was required is the registry should have given it to her for processing. It has not been done, but she has sent it. So we are giving it next week. Let her ascertain from the OC that service report. We are not asking you to take steps, but she'll get information from the OC.
But I know it's getting delayed because of that.
No, I understand, but do it 1 week doesn't matter.
Or bail
The
matter,
accused was about the 70 January.
It's okay.
And the case is.
It's only a week. It's only a week. We are not adjourning it for a month. We are adjourning it for a week. No. Part is bothersome. We don't know when brother and sister will meet again.
next week, logic is there. The list is some.
No, not that. But we are a unique family. We don't know when we'll next meet.
So I'll get the report within a day or two. Monday,
So
I will
Wednesday will fix it.
log it.
Mr. M.U. Mahmood, and counsel for the applicant, submits that he has taken steps several times for service of notice on the respond number 2. But the notice has not yet been served. Next, brother. Mr. S. Jahan, under APT, has submitted that pursuant to judgment of this court in the case of Ms. Jahan. Ms. Jahan, what is that case? That case? No, that case.
Oh, yes. This is the I'm getting, we we are like, things are not settled.
It's okay.
Registry also have not got any copy till date from the registry, neither from police.
It's okay.
Perhaps it will
Just
take
give the
some
name. I just want it for the order.
time.
I don't want to read it. I just want it for the order. Just give the
Oh,
name.
Lordship, yes.
Just like that.
Paragraph 9.
Name of the case.
Name of the case is Deepak Nayak.
Nayak.
Deepak Nayak versus State of Assam. It's criminal appeal J 40 of 22
Decided on
on 23/6/23.
in terms of this, the registry was required to hand over the steps to the office of the public prosecutor for sending it to the respondent number through the officer in charge of the concerned police station. So it is submitted that although the registry has not provided her with the notice, but of her own she has sent a notice to the respondent number 2 to be served to the officer in charge of the concerned police station.
No, back.
It's okay, whatever
I sent it long back.
I'm not on that. Next paragraph. Accordingly, the learned AVP is permitted to send a reminder to the officer in charge of which police station?
Bagbor.
Bagbor police station in the district of Kolkata, seeking return of the service report, which shall be done through the VHF facility in the installed in the court. Next, based on
Wednesday, 30th.
308/2023.
Next time there will be no adjournment. See the report comes.
No, we don't know. Tomorrow is another day always.
But Bagbor, I remember I sent it only last week.
It's okay. We are not questioning you. That is that we need that service report.
Item 10.
So you have to ascertain correct address. How much time?
I will also have taken paper publication. It's not paper publication. But they have not appeared.
If you take paper publication at a wrong address, doesn't serve the purpose. Correct. Supposing you want to serve me a notice by giving the name as so and so, Judge Calcutta High Court. It is served in newspaper. Will I get it? No. Ms. B. Talukdar, counsel for the petitioner, sorry, appellant, has referred to the office note dated 22/8/2023, wherein it is recorded that the notice sent by registered post was returned back with postal remark inverted commas. No such person in the address, inverted comma closed. So accordingly, the learned counsel for the applicant, appellant, wanted 2 weeks time to ascertain the correct postal address of the respondent. This after 2 weeks. You will have to first ascertain the correct address. Tell us the address, then only.
Item 11. mentioned the pipeline is very actually the subscription of franchise. Here, the query whether the petitioner is ready and willing to undergo the DNA test or not. So I have to say, option is absolutely requested to distribute the kit for merit.
I'll find my option.
Yes,
Here is the substitutes for which can other system 376 for 12 years. And in surveillance, you will also find PW7.
PW7. Yes. Yes.
So, if you also see the cross part, cross also is the government has spoken out to was that, and she did not identify the appellant before Germany. So how this name came, that is not explained. And in first line of that second paragraph of clause, she said, I have not identified Sudip to Germany. The ladies told me the name of the accused as Sudip Vijay. I have not seen the face of the person who caused me on the night due to that day. So that identification is not there. The name of this appellant was claimed by the advocate to the team. And even series of contested visa, this is the person. And at the time of occurrence, the appellant was 20 years old and the victim was 48 years old. Regarding identification, there is nothing that is the appellant who committed the. She was not filed any case. The other ladies who co-start to lodge the case. During trial, she was on case of she was never missing the device. And at present, he is about 1 year in custody.
It will be 1 to some first page. Next page, page 2. Page 2, page 2. Page 2. We propose to hear the matter on merit. Even if the paper book is not ready, we will discuss with the paper book, and if you want, we'll take up the matter for hearing. So whatever, even today, if you want, we'll take it up.
The position will be something, but the position.
You choose a date of your choice. Take a date of your choice. Next Monday, 28th. Right?
That's here perhaps.
Hmm?
That's here.
20th.
Right.
28th, Monday.
Monday. We'll say that paper book is not necessary.
No, LCR is there.
The LCR is available. Huh.
I think the devotions are in English. Devotions are in English. Identification otherwise is there in 164 and 161.
So whatever, he has a point. He has a point.
But then she knew her mother, his mother. And by name, she didn't know he was Sudhir. But she used to address him as Buddha in 164 and 161.
It's okay.
So we will
We are
see
not
when
applied a
we
mind. We are not applied a mind right now.
So Monday here.
Mr. HRA Chaudhary, Senior Counsel, assisted by Mr. A. Ahmed, Counsel for the applicant, and Ms. S. Jahan and the APP for the state. It appears that the effort which will be taken to dispose of this bail application from the main appeal can also be heard with the same effort. Accordingly, as paid for the learned senior counsel for the applicant, preparation of paper book is dispensed with. Yes. Next, as a LCR is received, this is the matter for hearing on 28/8/2023.
If there are other matters, maybe take responsibility. Yeah,
We try to take up. This connected appeal for you.
Item 12.
Yes.
The matter is appeal against conviction under section 6. There is a delay of 170
One.
days.
What is the explanation? This is a boxer matter.
Yes. Let it be heard.
Then appeal county jail.
I had received a letter from High Court Legal Service.
Oh, achha, this from jail. Can we allow this condone the delay?
So under the manual, they should be immediately informed about their appeal rights, but then it sometimes it's delayed, so.
This is I had received a letter on 27th June.
27 June. Okay.
And I have already received the judgment copy and the FIR along with the fingerprint statements. That's all.
But we say concerned counsel for the applicant and this is Jhan and the people of the state. Next. This interrogative application has been filed under section 5 of the Limitation Act for condonation of delay of 172 days beyond the period of limitation to in filing the accompanying appeal. Next. The Learned Legal Aid Council has submitted that it was only on 3/6/2023. 3/6.
Shadow June.
3rd June is 3/6.
Yes. And the convict written letter on
3/6. The applicant received information that he had a right to file an appeal against the impugned judgment, and accordingly, on the same day, he wrote to the Secretary DLSA Kokrajhar through the Superintendent of District Jail Kokrajhar expressing his intention to file an appeal. Accordingly, the Secretary DLSA Kokrajhar wrote an application to the Secretary of Guwahati High Court Legal Service Committee on 12/6/2023, and accordingly, the Learned Council has been engaged. So it took some time to correct the documents. And on 27/2023, the Learned Council had received documents through WhatsApp from the DLSA Kokrajhar, and accordingly, the connected appeal was prepared and filed on 11/8/2023. Next. Although the learning the APP has objected to the combination of delay, comma, but having regard to the nature of explanation given by the applicant, comma, the court finds that the delay causing filing of the corrected appeal was not intentional, as delayed information was received by the applicant in jail. So accordingly, what is inclined to allow this interrogatory application by condemning the delay of 172 days beyond the period of limitation in filing the corrected appeal. Next. The registry shall now register the corrected appeal and is the same for admission. For admission.
Items 13 to 15.
Also, there was delay of 36 days in filing of the appeal.
36. They're seriously contesting.
Would come from the application and not make a real concern. And I have suggested talking to letters and also that there is a change for mediation method. For
It is always better. You made a right. Yes. Yes, you said something. I did not. I miss it out.
This I is for period.
Huh.
Yeah.
Or should it be aware of the objection is fine.
Pardon me.
Paper book is waiting about it. Whether I have final objection.
No, objection is not there. Objection is not there. In fact, within how much time we'll file it?
Or should everyone of this paper book is ready?
Yes, it's ready. It's ready. No, but once the APP wants to file an objection, I'll have to.
Check when there's an order from the Sonathan court. It's the matter for hearing.
No, this, you see, this IA is filed where there's no order passed. At least there is not there in file. You see, this IA has come up for the first time. Earlier, if it has come, I don't remember. Correct, because there is no order passed in this IA. Although this IA is of 22, but somehow or other it has not been. There is no order passed. So today we'll formally issue a notice. Within a week, you will file it. For the respondent.
The informant of the victim.
You want to file an objection?
But the main thing is that we did not receive the copy of the IA.
Give me copy.
That was it.
To me also.
Okay. But PP has received it.
Our office might not.
But give him
All
a
the
copy.
cases they
It
receive.
will. Hmm? Huh. Mr. AAR Karim, counsel for the applicant, is B. Bunyad, and a senior counsel and APP for the state, assisted by Ms. T. Bora, learned counsel, as well as Mr. S. D. Roy,
Yes.
counsel for respondent number 2 are present. Next. Yes. Let a notice we issued on this interlocutory application for suspension of sentence. Objection. Requested extra copies of this interlocutory application we provided to the learned agency and the counsel for respondent number 2. Objection be filed within within 8/9/2023, list on 11/9/2023. Paper, next part, in the meanwhile, the IA is separate. It's for bail.
Item 16 for hearing.
Just yes.
Here the time, the most important factor. Time relate us to the circumstances whereby I can please satisfy this honorable court that it was the subsequent accused persons who were in fact behind committing this offense, because they have been by the interim order to lordship looking to the interim order, that is from page number 97 to page number 113. The operative part of the interim order you can page 113 of the paper. In paragraph 44, considering all I find in health, that prosecution has failed to establish the case against the accused person given law written without clarity, cogent and substantial evidence, as the accused Nurul Islam is equated and benefit of. So here, before I enter into the depositions of the witnesses and other documents, I would attract to lordship's attention to the FIR and the exam. Here the FIR has been registered on basis of the judiciary. I will come to that particular lordship. First come to page number 4, lordship, the exam. Page 4, lordship.
Just a second. Page 4.
Page 4.
Just- Just now.
The case of the performance lecturer in media report. I think that's going to work with a house. Then the incident.
Just now. Respondent is private respondent is Noor Islam, accused.
Not sure. Yeah, not sure what is happening.
No, just now. Just one. Give it 2 minutes. such a hearsay witness. So it's a confession, say, he hearsay. PWD is a confession in police custody in his presence. So they take a good. He doesn't. Before we begin, Mr. Bhattacharya, 3 or 4 circumstances I am just addressing to you and to Ms. Mia. You see, PW2 is referring to missing mobile, which was recovered from Raju Ali and you. Sorry, Raju Ali and the private respondent. PW7 says that the confession, he heard that there was a confession given by the accused in police custody. PW20 says that confession was made in his presence but in police custody. And PW25, who is the IO or OC, he says that the appellant was with Raju Ali. That is the only evidence which I personally found. I have not gone through each and every document, but by and large, this is the evidence which is appearing. So if this confession is made in the police custody, if that goes, huh? So if that goes, then we don't find any infirmity in the judgment. No, I'll allow you. I'm not saying I'm not allowing you. But what I'm saying is that if that be the entire circumstances, then we find that the judgment privacy is okay, because the parameter to hear the appeal against conviction is a bit differently placed than. No, definitely. We are not saying that we are not hearing you.
I'm not entering or trying to change the mind of the committee. I've placed everything before the committee. First and first, if we just look for a moment of charge sheet. Here, what is happening in the charge sheet? There are 2 persons who have been charge sheeted, and one was age 20 years, one was age 21. During the course of trial, they examined 2 witnesses, CW1 and CW2. They have brought in certain documents where they have said that this person whose name you actually kindly see, his name is, I have noted down the name. His name is Yilhaz Uddin. And the accused Chashide, his age is shown as 21 years. You actually kindly see. His name is not Yilhaz. His name is something else.
Is Raju Ali? Is Raju Ali?
Muhammad Yilhaz Ali, alias Raju Ali. Son of Muhammad Nurul Islam of the King Sanpura, Jamia Bazar. Now, what has happened? This person, he was given to go on being a juvenile on probation of good conduct. Till today, he is absconded. Till today, prosecution is finding out who face a crime. So, the law is very clear. Even if somebody is a juvenile, he can be tried by the juvenile justice. But he has been allowed to reason behind ignorance. Until today, despite all efforts, prosecution cannot find him out. So definitely section 8 will operate on that. And now, if I just tie stitching the clothes, some chain comes. I'd like to say how the thing progress. If I make a new, I will take much time because Lordship has already read the depositions.
No, I said I have not read it. I just say cursorily.
Regarding the lordship that the person is absconding, lordship is ordinarily could do not have any jurisdiction once is declared a juvenile. Once is sent for like tried by juvenile justice court, the jurisdiction under the juvenile
Honorable Court probably will not have any say about that regarding whether he's absconding because it went to be the jurisdiction of this honorable court. So that
No,
he
perhaps
cannot
my
take.
senior colleague is because I'm appearing in that court also. So I'm little bit applied to the facts. Actually, what has happened? He was never sent to the juvenile justice court for physical touch. Had he been sent so, then juvenile justice court was competent enough to utilize the evidences against him. But he was allowed to go on a condition that
No,
after you
He
become
he was allowed to go by whom?
by the trial court. By the trial court. And on a condition that after you become measure you come. He came. Once he came before the trial court. Subsequently, he again absconded. So will his conduct now, Lordship, now he is the measure. Will his conduct now under section 8 will not be there?
No, in this appeal, we can't take cognizance of that.
Committal order reflected. He's declared a juvenile and Lordship
Case record is prepared
Yes.
for the juvenile.
prepared for the juvenile.
Juvenile
The
is
juvenile is
produced for the
proceeding
JJB.
immediately.
In this appeal, this honorable court will
So,
not be able to
Lordship.
look into this. Okay. But Lordship, can be seen, there was 120
Hmm?
120 viewers also. I am now pointing out and focusing up to the one who has been acquitted. After facing trial, no one is there. I will try my level best to satisfy this honorable court that yes, maybe the evidences are scanty. Because sometimes what happens, the circumstances are so strong enough that even other evidence may not be there. But the circumstantial may hint towards the guilt of this person. And then any other hypothesis may not be there. That is what I am trying to satisfy your lordship. So if I take your lordship, before I take your lordship to kindly come. So the first FIR which was lost by this information. That is lordship will find in case of 116 and 117. So lordship is kindly got it. It reads as such, lordship, I have the honor to inform you that my sister-in-law, Dr. Deepa Devi, a selection grade lecturer of Zoology Department, particularly found dead in a residence, Professor P.M. Alexander Devi, particularly under mysterious circumstances. I was informed of the incident by one of my colleagues at 8:40 a.m. in the morning. I request you to make an immediate investigation of the death, which appeared to me as unnatural thinking. Now, what you can see here, on basis of this information, a UD, unnatural death case was registered. That is in case number 117. That was registered on 18/4/2010. Now, what you can become? The FIR. There are already citations of our own High Court that in such situation, if there is a
This is an FIR which is lost on which date?
document which was lost on 18/4/2010 as appearing from page number 117.
18/4/2010.
2010. And then Lordship pending come to page number 4 and 5. It was a UB case also. It means a GD entry was there. Although no GD entry number is depicted in that file.
Yes. Now which page?
Now page 4 and 5. This FIR was lost Lordship by SI Karuna Bolia of Latashi.
Yes.
I have the honor to report that on dated 18/4/2010, employment Dr. Ovid Kumar Vora, Professor HUD of Zoology Department, Guwahati, lost an hazard to the effect that his sister-in-law, Dr. Deepa Devi, lecturer of Zoology Department, Professor Guwahati, was found dead in a residence, Professor Colony, flat number D3, Muhammad Nurul Islam of Muhammad and Muhammad Nurul Islam, son of Muhammad Samun Haq of Rutumashi PS, Kolkata, have committed robbery and murder conjointly to the victim on 17/4/2010 at 5:30 p.m. to 6 p.m. This time is very important. 5:30 p.m. to 6 p.m. While this is because it was alone in a quarter in the course of investigation of the above case, which is a counterpart of the murder, it is crystal clear that the accused persons committed the robbery and murder. In course of investigation, the mobile phone of victim Jai number 7 has been recovered from the possession of the involved accused Raju Ali, near previous Jinhas Ali, which is seized under the seizure list. The accused person confessed their guilt and that the process of the investigation both theoretical and received robbery and murder. So requesting to kindly register a case under the position of law and during the investigation. This affair was formally lost approximately 24/2010. Received registered membership case number 72/2010, dated 22/2010 under section 394 of IPC. If the lordship kindly comes to the PO. So page number 130.
Page number
130, starting from 130. I will draw your lordship attention. Page number 136. Opinion regarding cause of death is kept pending in receipt to the report of the chemical analysis of this area, which has been sent to us. Time since death 12 to 24 hours. Now this is important. Now you kindly see when this PM was enquired. It is in page 151. Examination on 18/4/2010 at 2:15 p.m. It means the victim ought to have died somewhere in between after 2:15 p.m. of 17/4.
I don't know, did it please repeat again?
The lordship looked into page 131.
Examination is 2:15, 18/4, right,
Then the time since that is one in 136.
136.
136.
24 hours.
Yes, 12 to 24 hours. Meaning thereby, whatever has happened with her has happened after 2:15 on 17/4. 18/4 was the 17/4. Now, lordship kindly come to FSL report. It is in page number 138. I am of the opinion that that was due to asphyxia following anti-mortem smothering, which is homicidal in nature. It is strangulation. Now, I would take the lordship to certain scissors. Particularly scissor of mobile. It is in 124 page number.
Page
124. On Samsung mobile
this
headset,
postmortem report is exhibit.
Lordship postmortem report is exhibit 6.
6.
And the serial list which I am attracting your lordship attention, that is exhibit 4.
Exhibit 3. Page 122.
124.
124.
124 is the seizure of the mobile. Samsung handset, mobile. It speaks of the place of occurrence. Only four is particular. 4 and 5. Russians can find the first article seized. 1. Samsung mobile handset, right? IME number 0. If we indicate back to the FIR, Azhar says this IME number 35968100248223, the same mobile of the victim. That's why question arises, what this mobile was doing with them. And now, just for a moment of time, where the confinement victim, Raju Ali, alias Julhas Ali, son of Mohammad Nurul Islam, which is the present petitioner, father and son. They are not anybody unknown. Second is Mohammad Nurul Islam, son of Mohammad Shamsul Haq. आपने लोग एक दूसरे टेक्निक को
Just a moment. Just for your information, this check the LCR. As per the LCR, the form of FIR reflects the registration of FIR or receipt of FIR at 9 p.m. on 24/2010.
Thank you.
Correct. Now, therefore, it would mean that the seizure is made first. The mobile IME number would be available and therefore it's entered there.
What they have done, just they got information. They have raised an UD case. After they raised an UD case, they carried out an investigation. In fact, on 18/4, the UD case was registered at the morning. Then they took 3-4 days. They traced out the mobile. After they traced out the mobile, then this FIR, this formal FIR, was given by the SI of the federal. Now, the question arises that whether there is two FIR and it is hit by the TNP. I would submit to you. The first FIR will not one which is elaborate or not giving a cognition possibility. Therefore, this FIR will perhaps not be by TNP. And there are some observation of this honorable High Court also. In such situation, if an FIR which is disclosing a cognition offense and meet up 154 CRPC, then there is no harm in considering it as a first offense. Now the question is, the honorable court is speaking for me, whether the seizure will be correct or not.
No, seizure is okay. You don't find the fault with the seizure. But you said that the same number, mobile number is entered. Therefore, we saw this form and found out that in our observation, we find that the seizure would precede the FIR, and therefore the IMI number finds entry in that FIR.
In the FIR, because they have first, if the lordship reads the statement of section PW7, there will be some clarification. Because there was a news in the, I don't want to tell the media, but there was a news that how these 2% were intercepted by this. And then that PW7 says that when that mobile was shown to her, PW7 is the niece of the victim. She said that this mobile belongs to my family. How question that arises, a strong circumstance that arises. So what it is doing with the education. And one thing is silent, but I did not find out. It might have missed my notice. Had they also been having their own mobile, then their location at that particular point of time that will place out. But they are not having any mobile. I did not find out in any evidence that they were also having their own mobile. Whatever may be the cost of the school. So therefore, it happens like this. That they were there because I was back to the statement of PW1, PW2, where it says very clearly that carpenters were working. PW1 says that there was a phone call where the victim said that no, I cannot go today. One carpenter was supposed to come. It is the statement of the victim just before she died. Then, after that, the lordship finds PW3 also. They also speaks regarding PW2. actually, this paper book is like this. I'm sorry to show you, Lordship. I'm just reading the one part.
Page,
Page 12, please, Your Lordship, can you have it? I'm not able to read it.
page 12.
Page 12 and 13. There is PW2. GC Nip Kumar Nap. The victim happens to be his cousin. Most important PW7.
No, page 13 doesn't matter.
Doesn't matter.
I'll tell you the reason why. Page, come to page 12. We start with an oath, correct? The chief is complete, cross is declined, page 13, correct? So the down below is an impression of the PW, what you call 3. Now you see PW 3, it will match.
I am listening. The 20 and 21. Elaborately, they have said how police is finding it. And why she is saying that this mobile number belong to her aunt. The elaborate explanation is used.
You're reading which PW?
PW7,
7.
page 20, 21, 22. 22 is the class. The first paragraph it says what she is saying regarding the code, the mobile.
Right. Is it one? Exhibit business. Exhibit 3 is page 122. Page 122. Curtain. Curtain spring wire. Listen. This is present. This is one. Exhibit. Automatic exhibit. Left 9. Index. Take a break and come. Is your speaker on? I'm missing your voice.
I'm sorry.
I was happier when I couldn't hear you.
I was not with you. So what I was reading to watch it. Yes, PW25 is one of the most important witness. In fact, he lost the formal FIR and he said what it that when the inquiry was going on, the mobile handset of the victim was missing. So he took out a CDR, and from CDR he found that there were 3 calls in that mobile handset. And when he has traced those 3 calls, he found that these 3 calls were from Gujarat. It is the Vilasam. arrested. After that, page number 77, Mas, after being arrested, Julhas told that along with him, there was another accused person who was on that day in the scene that he was Nurul Islam. Accordingly, Nurul Islam was arrested. So here 34 is there. So that statement is not a confession. That statement is rather leading to a discovery. That statement helped the IO to arrest Nurul Islam. It is in page number 77. Just read it out. It is very clear. 76 and 75 and 76. I just want to read out. Postmortem examination was conducted. In video recording of the same was done. After collecting the misery, I returned to the police station. As it grew dark, that day the disabled presented the center station in the disabled kept in the hospital for the peer under the custody. On the following day, that is the 19/4, I sent a disabled exercise examination. On 19/4, the deputy was under the custody. During investigation, I recorded statement of Dr. Guru Kumar. From his statement, I came to know that this is a mobile phone number and then went missing after the incident. The number of the mobile phone was 9640644. In order to create the location of the mobile phone, I made a request to the border officer of the police. When I collected the CDR of the mobile phone, on perusal of the CDR, it was found that on 17/4/10, the day on which the deceased died, the mobile was switched on since, this is very important, switched on since 2:05:32. That means 2 hours, 5 minutes, 32 seconds to 4 hours, 54 minutes, 30 seconds. As per the call detail, the IME number of the mobile phone in which SIM number 98640 was inserted was 35968100248230. On 19/4/10, I came to know that the owner of SIM number 9937198218 Muhammad Bilas Ali Jagan Mora Borpeta Jania made a phone call to the district Devi at 3:26 hours PM and 4:32:59 PM. In between 4:23:13 PM, the deceased made a phone call to Julhas. It is the same number shown so. Lying emphasis on these three calls, the service provider was given the IME number of the phone and asked to track the location. According to the service provider, calls were found to be made with the mobile phone number bearing IME number of the deceased person's mobile phone number using a SIM linked to phone number phones. That means after taking the phone, they were using it. I need more words. The said phone belonged to accused Julhas. In the meantime, the service provider showed the location of the SIM number so at B. Burwa Road, Guwahati. Then I made an inquiry towards B. Burwa Road, Guwahati, and at that time, additional as the CPOC, the service provider and my staff were with me. According to the service provider, the location of the phone was found at Cottage India Otuboy Furniture Shop at B. Burwa Road. We immediately apprehended Julius Ali. So he is a carpenter. The user of the phone number 9937198218 and the owner of the phone number is the same shop. The Samsung mobile handset with IME number 727 was 6 along with this one pair of sandals. Then Kito was given IDS Gold DLS number 2GB memory card, a cotton t-shirt. The same materials were seized from Julius alias Raju Ali. The signature Raju Ali after erasing Raju Ali on 24/10. When I received the postmortem report, I lodged the FIR dated 25th for registering case in connection with the murder. Exhibit 12 is the state FIR. On the receipt of the FIR, the also the Ladakh case registered the Ladakh case number 73/10 under section 394/302 IPC dated 12. When entrusted me with the charge of the investigation of this case. Exhibit 12 is the signature is the OC 7. It may mention here in there on 24/10 at the time of arresting Julhas alias Raju Ali, it was known that there was another accused with him whose name is Nurul Islam, as shown by Julhas Ali Raju Ali. On the same day, Nurul Islam was apprehended from Kukuri Park, Sharapet. So this is very clear that both of them together were there in the place of occurrence. Now, what you can see when the charge sheet was submitted. The sheet was submitted at 399/202 and 34. hardship. He's working in a furniture shop. Rashid, if you find in page number 160, forwarded to civil pro under section 394, 30 to 34. 34. Right? Sufficient for option.
Oh.
Circumstantial evidence. Gode Lakshmi Mangraju, yes, Namrek was the state of Andhra Pradesh. It is 10 July 2001. You kindly see page number 2 also. Third paragraph. The case against the accused was sought to be proved by the prosecution with the help of circumstantial evidence. Large number of circumstances were presented by the prosecution. The trial court and the high court enumerated those circumstances connected to the evidence. Both the court found that those circumstances were well established by the prosecution and they were sufficient to form a complete chain pointing unerring to the guilt of the both of them. Accordingly, the trial court as well as the high court found them guilty under section 404, rating section 34, and convicted them and sentenced them as associates. I am on those full chain of the circumstantial evidence. It is true, there is no eyewitness. It is also true that since there is no eyewitness, none have seen them. It is also true that there is no theory of last seen today. But what you cannot discard those statements of those people who say that yes, there was a carpenter once. Carpenter was called, carpenter was there, and Ayo has categorically stated that Julhas Ali, he made certain phone calls prior to the incident to this lady. That means the time was fixed, that they are coming to your home on such and such time. And Julhas Ali, maybe he is not before your lordship, was passed as a state from Bigora Road from a financial shop. And Julhas only said, because lordship there was no evidence for the police. The Nurul Islam was with us. Now, I do this. Taken the name of some other person.
Yes. Just now. Page 114. Page 38. 38. Last paragraph, last paragraph, last. Is it Caesar list? It is 124. Caesar list. To be repeats. The final impression is also was from Stephen Ewing analysis. Circumstantial evidence to material evidence. Yes. Yes.
I would read section 27 of the evidence section with some emphasis.
Evidence Act. Yes. Evidence Act. Yes.
How much of information received from the accused will be proved? It has always been lordship that leading to discovery speaks of only tangible things, but I'm not on that. My submission is your lordship. Even if those are facts, that may also be proof if it is coming during investigation leading to certain discoveries. I read it, lordship. Provided that when any fact is deposed, I'm putting emphasis on the word used here, fact. Who has discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much such information, whether it amounts to a confession or not, as relates to distinctly to the fact thereby discovered, may be proved. So here he says, so and so was only that extent. Whether it will be hit by 25 confession or it will be 27. You will kindly see there is no other evidence, and he is not making any inculpatory or exculpatory statement. He says that he was that much, and then he was arrested. There is a judgment needed to that. I could not lay my hands to that question, but it is written down here in the comment itself, in the book itself. A fact discovered in an information supplied by the accused in his disclosure statement is a relevant fact, and that it is only admissible in evidence if something new is discovered or recovered from the accused which is not within the knowledge of the police before quoting the disclosure statement of the accused. This is in Kamal Kishore versus State Delhi Administration 1997. 2 crimes, 160 in Delhi. So before this accused was arrested, police was absolutely in doubt whether there was 1%, 2%, or 3%. Moment he was arrested, he said that it is there. And I would submit to your lordship. If your lordship read out the entire evidence, it is not the case of Nurul Islam. No plea of alibi has been taken. No plea of alibi has been taken. That he was not there. This because the handset has not been recovered from him.
Can you come to section 3 of the Evidence Act?
Interpretation clause.
Yes. Fact means and includes anything, state of things, or relation of things capable of being perceived by senses, any mental condition of which a person is conscious.
Now if we read it closely, any mental condition of which a person is conscious.
Yes.
He is conscious that Nurul Islam was with him. And that is why he has made a statement. He could have made a statement regarding
So-
X, Y, Z, anybody. But he is saying regarding only one person.
So therefore, you please come to Constitution C, that a man said certain words is a fact.
Yes.
So he said
Nurul Islam was with him.
was with me. That is a fact. But the
And
but that doesn't prove the crime.
when I have connected again. If it will not make a crime, if nothing had happened out there. Because now if I read 34, let me read 34 further. Act done by 7% in furtherance of common intention. When a criminal act is done by 7% in furtherance of common intention of all, each of such person is liable for that act in the same manner as if it were done by him alone.
No, my mom is. There's a query. In participation of a crime, X was with me. Correct. It amounts to a confession, but it also amounts to implicating a co-accused. So how much of a statement of a co-accused against a co-accused can be used? That is another legal proposition.
That is why I am hampering on 27 lawsuits. Because lawsuit will kindly see.
27 is only one part, but that is not the law doesn't say that once the co-accused makes a statement that X was with me, he becomes a partner in crime.
Submit it in other way. That Nurul Islam, be an innocent person. He was in a liberty to take a plea of alibi. Yes, rather, jurors, there was entire focus to prove jurors are juvenile. At the first end of the trial, what you see, after examination of 20 witnesses, CW1 and CW2 is automatically got into picture. And that also, since he is not there, I should not submit. Whether it has been done in a correct manner or not, that is also because the law prescribes certain procedures how to deal with it matter of juvenile. And if he is juvenile, but he was doing in the shop, arrested. Let us forget those parts. I am into that limited part. It's a very difficult area. It's a tough area for intervening. And once when it is an appeal against executive, I understand. It's very tough. But I
I would not even remember the day I started working in my own shop.
It is not the fact.
It's not that.
Fact, Lordship, is this, we have to remind lot of things.
No, that's okay.
If a person is
But
working in
my
a factory,
working as a minor,
there is an act, Lordship is doing it.
no, that's okay. But what I'm saying is that the age in when I started work, I won't even remember. Because
If he does not remember,
I was,
if he doesn't remember.
no, I'm speaking of myself.
Oh, I'm sorry.
The day when I started to work, I won't even remember. Maybe I was 6 or 7 years of age when my parents inculcated habit on me
That is why Lordship is.
to sit and work.
That is why Lordship is here.
No,
Lordship is now.
not that. But age of minority is
No,
that
I'm
is
not-
something which
I'm
is
not on that, Lordship.
very foreign to us.
This court cannot decide. I'm not on that. I am concentrating on Nurul Islam only. And what is the evidence of against Nurul
No,
Islam?
you see, there are certain things which are we do not intend to obstruct you when you are arguing. But you see, there's although you are trying to project that there's a connecting, there's a thread which is connecting all the circumstances against the response number 2. But you see, the CDR is connected. CDR is not proved. The mobile is seized.
CDR against the accused number 1 is improved. From there only they got hold of it.
No, but you see, please come to this page. If you can demonstrate, otherwise I don't know. Page 114. Prosecution exhibits are mentioned there. So CDR is something which I did not notice. Correct. It may have been this because there is a blunder here. Material exhibits are not given. The court has omitted to give the material exhibits. So there are certain material exhibits like that chappal, that like mobile cover. So those are there. We were when we were discussing, we were just
Since there was no clear verify by Nurul Islam, we cannot doubt the statement made by the co-accused. Even on basis of that, he was arrested. Had he taken the name of some other person, then Nurul Islam would have figured, then would have understood. He is specifically saying the name of Nurul Islam.
You see, I go back to the Jen Diary cases. Here I would not remember 94, 95. Jen Diary.
Yes.
I won't remember the dates. But there was a unique proposition. You know that proposition. It comes up every time when this proposition asset case or those cases come. We have dealt with it. You see, there I was just reminding myself. What happened was that in a diary, which is that Jen Diary case, there certain amounts were written against certain names. So, given so and so to Prime Minister, given so and so to ex-MLA as MP. Those amounts were written by name. And the person says that he has given it to those people as bribe. But in the Jen Diary cases, ultimately the decision was that that amount of proof which is coming from the co-accused would not be incriminating against the.
At one line, intervene to worship and mix with. That's a case of this proposal they said.
No.
If there is no recovery or nothing to make up any disproportionate, it's different.
No, that was a case where the amount got what you call prosecution started under the section 7(8) of the Prevention of Corruption Act, and this was a proof that these provision assets were there because this is something which is coming on record. Facts have to back.
Difference between because it's a case of 302.
No, it's okay.
And it's a case of 34.
No, it's okay. But what I'm trying
Have you
to
taken some clear alibi law?
no. What I'm trying to ask you is that that's why we are not disturbing you then. If the CDR is not
CDR, so for CDR is concerned, CDR is regarding Julius. Because on basis of those CDR, they arrested first Raju Ali. After Raju Ali was arrested, Raju Ali said that along with me there was one person. Who is that? Nurul Islam. That is how Nurul Islam got arrested.
Correct. You are saying that this is a part of something which is covered by section 27.
Absolutely.
We are disinclined to agree to that because of the fact that it also amounts to admission by a co-accused. How far it will be fatal to the co-accused,
Now-
that you have to explain to us.
How far it is
Section-
to co-accused.
No, how far it will implicate the co-accused? No, not fatal, it will be implicating. So
So,
that's something you'll have to.
Lordship, here, what I try to say is, Nurul Islam knows what has happened. General human conduct. Now, he was at liberty to take the plea available.
No, he has a right to remain silent.
I have to remain silent. The Lordship can see is one, see the 300. No explanation at all. No explanation. It is false, it is false, it is false, that's all. And Supreme Court, I think Lordship recently has been heavy on this. Some explanation we have to do. And then,
I think if I have a right to silence, nobody can dictate terms to me, but if there is a judgment, I don't know, I'm not aware of it.
Prosecution has to stand on this first.
No, I don't know. If he says that there is a judgment, I'm not
the
aware of it.
prosecutor is saying something else.
No,
Prosecutor is-
whatever may be, I have to place it on record, your lordship. Once the proceeding has stand on its own legs, then remain at 313 will count, your lordship. First, the
Prosecution has to do its
But
own.
sometimes it happens, your lordship, all the questions were not put to the accused person. That sometimes we should.
No, it has been put to you.
Incriminating material has to
And
be put to the
prosecution
accused.
stands in its own land. Here, the incriminating materials very clearly shows Lordship, because if your Lordship looks into the postmortem report, the victim gave a tough fight. If your Lordship looks into the inquest, she has gazed some cotton, that is the curtain, and some curtain was found inside her mouth. Can it be handiwork of a single person? If you look into that circumstances, can a single person do all these things? And then why the co-accused is saying so and so is present. Specifically taking the name. Specifically taking the name. Just to leave it up to the option. To submit that here there are clinching evidences which the court below has failed to appreciate. Because there was two things why the court below failed to appreciate. Number one, the accused is taking a specific name of a co-accused. 34 is there, charge has been framed under 34, that has not been discussed. No plea of alibi has been taken by that. And he has said one thing. If you take it in a different way, he said that I am not a carpenter, I am a rickshaw puller. It is that part he could have proved it. That also he has not proved it. So I say that prosecution has proved it that on that fateful day, there was this 2% who has committed this offense for the purpose of robbing out that mobile handset. Because at that point of time, if an can be recognized, this period of time is very crucial. 2017, those smartphones have started coming in the market. There was a craze for it. And this is the motive which has triggered all this. Just to leave it up to you.
This you have a decision to support the point that
Regarding the
that
circumstances.
that the statement by one of the accused naming someone would be covered by section 27.
I will work. Your lordship kindly give me something.
Yes.
Head of this case is that, my lord. In the trial, my lord, there are two accused forwarded, my lord. One is Razu Ali Ala Julas and another is Nurul Islam. But my learned friend pointed out one thing, my lord. So both are father and son.
You have heard everything. Whether you to note of that, that's something else. When somebody said something, we have heard it. Whether you are taking note of it is a different matter.
Yes,
It's
yes.
in the FIR. It's in the FIR.
No.
How can he say no?
Why I am saying no?
Then he says he's not a juvenile.
Why?
Then how can you take two things?
But you lordship come to the page number 4, my lord. This is the affair, second affair. This is the second affair. Page 4, my lord, second affair. During the investigation, the PO was visited at some several witnesses and it was found that the accused member Razu Ali Julas, son of Nurul Islam, my lord. So the name of the Nurul Islam both are corroborated, my lord. But lordship see the address, my lord. Sonia Bazar PS Gorpeta and the accused number 2, his address is Rupa Kuchi PS Gorpeta. Both are different, my lord. And if this can be happened, my lord, then it should be written as the both are from the same address. Even my lord, never whisper about that, my lord, whether they are son or father or son. Never, my lord. In the lordship goes with the entire
This was a trial to find out who is the father, who is the son.
my lordship.
Then it would be unnecessary inquiry.
Yes.
Even if the addresses are right or wrong,
Yes.
will it vitiate the trial of the crime? Let us say the address was X.
My.
They have written Y. Will it vitiate the investigation of a crime?
No, my.
Then
But my, it was not correct when I actually pointed out.
no, those things are not material.
And the second thing, my lord, the evidence which may have only corroborated me that I, the Nurul Islam, against me, my lord, it there is no evidence. Only things we pointed out that one is the confessional statement made before the police, my lord. And the second thing is that, my lord, the accused Julas, my lord, Razu Ali, my lord, who called me on the date of the occurrence, my lord, as per the version of the police, prosecution counsel. Version of the prosecution, my lord, is that, my lord, they trace out the mobile from the accused Julas Ali. And during trial, my lord, they never produced any record related to those things, my lord, whether the in the which way they were traced the call and how these things were corroborated before the trial court, my lord. If lordship come to the page number 73, my lord, which is the evidence of the IO, my lord, which is elaborated everything, my lord. According to him, that if lordship comes
Just a moment, Mr. Bhattacharya. There's one witness who said that he or she saw in that campus one thin person going out, or two persons going out. Which PW was that? One of the witnesses in that compound, he or she said that she saw persons going out, and she was not taken for TIP. He or she, I don't remember. Just find out in the meanwhile. By the time we are hearing.
Even, my lord, the lordship come to page 75, lordship.
Which page?
75 and 76. Lordship may come with 76 my lord. Third line, my lord. The said mobile phone belong to the Eco Zulazali. In the meantime, the service provider showed the locations of the chain to the number so and so and so. Then I made an inquiry towards the Biburu at the time of the SPCP service provider of the Mysore. My lord, as per the deposition of the IO, my lord, she deposed that, my lord, because it was conducted a surveillance, my lord. This was right out on the order of the additional SPCP, my lord. Even, my lord, the additional SPCP never before the court, my lord, to depose that thing, my lord. And never the telephone record, the call record were examined with the court, my lord. The only thing which is the main evidence as per them, my lord, as per him, my lord, connected with the Zulhas Ali with me, my lord. That is that he make a call with me, my lord. That is mine. But they never bring those documents before the court, my lord. And the next thing, if lordship come to the Caesar, my lord, that is the main point. Lordship will come to 124 case number. 124. Next case is 125 number.
Yeah, just one moment.
Mine.
I forgot your name. M. Ahmed.
KM.
AM Hassan.
KM.
Yes, which page?
Page 123, 124. This is the Caesar list, my lord. It was seized from the as per the police report, my lord. Those things were seized from the accused Rajwali. Lordship came to the next page, page number 125. There was three Caesar witnesses. One is R. Hazarika. It's perhaps wrongly written, my lord. It's actually R. Hawk. And second one is Asif Loki and the Hazarika. Lordship, this season number 1, my lord, was deposed before the court as that PW 12, my lord. Lordship, now lordship come to his deposition, my lord. This is on page number, my lord, 38. Lordship, it's 38.
38.
Yes, civil. This is 2012, my lord. May I read, my lord?
Yes.
I have also known by my nickname as Raju Haq. My brother-in-law Abdul Rahim has a building at the Bigova Road, Bubari, and one furniture shop is situated in the building on that. About 3 years ago, police came to the same furniture shop at about 4 p.m. along with a person under handcuff. My lord, as per the version of the police, my lord, the police collect the CDR report and police trace the IMEI number of that phone and directly went to the place of the in front of the Bigora College and red-handed arrest the accused Raju Ali, my lord. But as per the deposition of the PW2, my lord, he categorically deposed that, my lord. About 3 years ago, police came to the same furniture shop at about 4 p.m. along with a person under handcuff. Hello. Who was that person, my lord? And my lord, if lordship come to the next page, my
No,
lord.
this is, you see, this is, you'll have to tell us why you are referring to it. Because if you take that plea, then the person who was arrested and brought at page 39 is 22 to 24 years old. Therefore, this juvenility plea of the July study will go.
I never take the plea of
No, I don't know. You look at, since you are showing me page 38, I was reading page 39. By the time you are reading these two lines, I have read this on both the pages.
It's a different person. I'm going the later part. Lordship come to page 39, man. But at the time of when Zulaz Ali was not arrested, only police went there, and they called them as per the Caesar, the Caesar will call them to seize the materials, which was found that. At that time, the Zulaz was not arrested. And by the next one, page 39, my lord, lordship may come. Page 39, my lord. One Abdul Latif, it is about line number 5, my lord. One Abdul Latif, Abdul Khan also have shops in that buildings along with the aquarium shop. I have not seen anybody of those persons at that time. The person's whom police had brought on handcuff was aged about 22-24. I do not the name of the owner of the furniture shop. And the next part, I do not know the name of the owner of the furniture shop. He was also present at the time. One of the employees was present at the time in the furniture shop, whose name I do not know. I do not know whether the employee was. The sales articles were on the table. As part number 6 articles on the table. I never searched from the only put on the table. The sales article were on the table of the furniture shop. I do not know whether the police recovered this article as said by the employee. It is also contradictory. Whether those materials which were recovered by the police as per the Exhibit 5 measure, whether those were recovered from the accused actually or not, it is not confirmed by the Caesar policeman.
You are holding brief for whom? You are holding the brief for whom? Then you stick to your thing. Why should you be concerned that whether who has seized, who was not? The question is that this whether you admit it or not, it's a part of record that he told that Nurul, or what is his name? Nurul Islam was it? That is the fact. Yeah, other things are not material.
It is covered by section 30. As per my part of my knowledge.
We'll continue to.
The concession is given on
Because he says, facing common fact, here he was not the other point. This is why I submitted 27. 27 says regarding disclosure of fact.
Continue to. So what is the point you are trying to make? I did not get your point.
IO categorically disclosed that during the examination of the accused man, no one.
No,
can
you are
present-
showing me page 20. You made me read this PW 20. What is the point you are trying to make?
He pointed out that, my lord, the accused person confessed in presence of me.
Hmm.
But my lord, IO categorically disclosed for the trial court, my lord, no one can present during the examination of the accused person. How he can know how he may be present at the time of the confessional statement of the accused person. It cannot
Where is that? Where is that?
Which come to the post part is 80.
Yes.
Let's come to the sixth line.
Yes.
I know witness Dimeshwar Dekar. He is the minor PW 20 minor. He is the ward member of the municipality. Letter says he is a ward member of the village defense party. When we interrogated the accused person, the general people are not allowed to stay there. At the time of the interrogating accused Raju Ali and Nurul Islam, witness Dimeshwar were not present with me. My. That is a contradiction. I was saying that he was not present, but that is the point, my lord. My learned friend is argued on the confessional statement made with the accused person.
I never seen its confession.
Now, made by the, even when this confessional statement was made, this PW 20 is stated that this confessional statement was made before him. However, the IO contradicts this statement that no one can be present at the time of the integration of the accused person. And during the confessional statement, he was not present at that time on that.
Have you heard what Mr. Bhattacharya has said? Have you heard what Mr. Bhattacharya said? A statement made by a witness, is it a confession? Statement by a witness, confession.
No, I'm not.
No.
I never seen.
PW 20 is a witness. Will his statement become a confession?
No, I'm sorry.
No,
I'm sorry.
no, I just told you, be cautious of what you are addressing.
No, I'm sorry.
Ah.
I'm saying what
Because I had my experience there.
the
Pretty good experience. He is not a co-accused. He is only a witness. Witnesses, I heard it. It was done in my presence.
We have 20. I'm telling about the Raju.
It's okay.
And next thing is the circumstantial evidence. If Lordship
Just. Was there in the trial? You were not there. I think the appellant did not participate in the trial. Appellant did not participate in the trial.
He had some wanted where it is not reflected in the records.
It is a lacuna. কিন্তু lacuna বলে তখন lacuna তো এটা শুরু হবে। What is the name of Limbeshwar Dakar? Yeah. Statement they have to provide. Yes, sir. In chief. Remember, sir. I think you might- Contradiction to the government. Yeah, but we said, I remember. What did he say? Principal, no? So in this case, police and you both are right. The police is also right. His witness PW 20 is also right. The police has said that the police has said that when they ask questions from the accused persons, nobody is allowed to stay. He is right. The police must be giving a third degree. So therefore, they don't want anyone else to see the third degree. So therefore, police is right in saying that they don't allow anybody else to be there. And PW 20 says he heard it. Maybe he's right because he says that I was there when I had heard from the police questioning. So maybe when the police was giving third degree, he was shouting and then the man outside was hearing. Because we are reading the statement of the PW 20 under 161.
Yes.
Here also he has said. So therefore, my sister in writing saying, when there is a positive statement in 161 and in 160, in the cross exam, you don't contradict him by showing his earlier statement, then perhaps it will not help you. Like the OC you have cross-examined specifically to bring out contradiction, but to this PW 20, that you have not made any attempt to contradict him. In his statement, he says, look at this. Second paragraph. I just for your purposes.
আজি ইংৰাজী 20/4/2010 তাৰিখে পুলিচে উক্ত মোকৰ্দমাত দুজন ধৰিছে বুলি গম পাই থানালৈ আহোঁ পুলিচে জেৰা কৰাৰ ফলত মই শুনো যে উক্ত দুজন খুনিয়ে ডক্টৰ বিভা দেৱীক যোৱা ইংৰাজী 17/4/2010 তাৰিখে উক্ত চৰকাৰী বাসগৃহত ফাৰ্নিচাৰৰ কৰিবলৈ আহি বিভা দেৱীয়ে মোবাইল ফোন লোৱা বুলি চাই কৰোঁতে দুজনে
No, this is not important. Last line is
Yes,
that
yes.
two people are arrested,
Yes,
but he heard.
hard.
So hearing maybe you may be there to hear it. You may not be there and still hear it.
Yes. My God. So it was not your lordship. According to your lordship, I have not gone through the cross-examination part. It was not contradicted.
So somebody has heard it.
Yes.
And it was not contradicted. He had not heard it.
Yes.
Yes,
My lord, his lordship comes to 58, my lord.
58.
Yeah, my lord. His deposition. Deposition of your 20. Meaning that cross, my lord, it was try to contradict, my lord. Last part, my lord. Last 3 lines, my lord. Besides this, the police station, another incident also, and I have given my evidence once. I know Loknath Deta of Joypur, his mother-in-law lost the case against him at Lokashil police station. I do not know if any warrant was issued against him. It is not a fact that in order to suppress the execution of that warrant, I exerted my influence in the police station, and in absence of that, I exist to give the evidence in connection with this case.
Nothing comes out of it.
Yes, my lord. Right, my lord. And my lord, next part, my lord.
What is that? Lal Badshah. Lal Badshah. You remember Lal Badshah? No. It's in one of the Hindi movies. Amitabh Bachchan is the witness. And he's asked, what is the height of Lal Badshah? He said, then he said that, no, then you don't know. It's a hen. Murgi said, no, you have not seen my next hen coming. So the name of that hen was Lal Badshah. What is that movie? The classic movie, Amitabh Bachchan is a witness. Iman Dharam. So it's assumed that there's nowhere. Anything else in your case would not be enough. There is only statement made against you to implicate is that statement of the co-accused implicating you. There is nothing more against you. There are people who have seen two people going out of that room, of that complex.
With PW6.
Hmm?
PW6 only say that you in the cross, that he knows 2% came.
It's there. Somebody has said, I don't remember. Somebody has said, which I don't know.
Our 3 persons came on the charge.
I've seen that. Once I've read it, I remember it, but I do not know the sequence, but I remember it.
I heard
No. In
I
the
heard
cross-examination, just a moment, brother.
No, somebody has given a positive statement.
Yes.
He or she saw
In
coming
his
out.
cross-examination, he says, I personally know about 2% came to our house. No,
His lordship came to find 19 May. It's 19 May. It's 91 May.
you confuse him in his cross.
Somebody has said so. I won't remember the sequence because remembering, I don't have that photographic memory to
There is
remember.
19 only.
Then 18 and 19.
I presently do not know the exact date. I heard 3 persons came. I personally know about 2 persons came to our house. I personally came, 2
That's the
persons
last
came.
line, Lordship. This is the cross. He said, how it happened, I will tell you. Lordship knows very well. In the trial court, what happened. I just read out. At present, comma. I do not know the exact date and time. Full stop. I heard 3% come on earlier day to the residence of the deceased person. Earlier day. I personally know about 2% come to our house. The last line is finished.
That is
It's
in cross.
inclusive. It's in
And
cross.
that is in cross.
No. He knows that 2% came. Previous day, maybe 3% had come. But on the day of incident, 2%.
No, ma'am.
I heard
Never
previous
said
day,
that 2%
evening,
from-
two persons came to our house for
I
making a
personally know
almirah.
about 2% came to our house.
I personally know about the 2%. 3% come, I know 2%. That is the version.
No, whatever be, you see, whatever two or three things, but the presence is there.
When
the
they
question is, who is-
personally know the 2%, that means those 2% who are usually come to that house, ma'am. Not these
Crossing.
2%, ma'am.
Have you been
No,
crossed?
Roshi,
I'll tell you.
evidence of PW9, I don't know paperwork because it was the last item, so I did not take adjournment. PW9, Nilimanat, 17/4/1905, the victim told that one Raju Ali with one helper was coming to her residence, taking measurement of little Almira, PW9. Not just
Her
down the residence.
sister. That is why I said it is a crime declaration.
PW9.
It will be prisoner 25 onwards. It was 25.
Ha, Rajuli in one helper.
That's a crime declaration. Yes, 32 circles on four.
Huh?
Yes,
In order to do dying declaration, the circumstances.
32.
32 circles on.
32 sub clause A. A,
It's one.
one, so one.
Very clear.
Kaushik, when the statement is made by a person as to the cause of his death or as to any of the circumstances of transaction which resulted in his death.
Yes. I don't know.
In cases in which the
Such
cause of the
statements are
death
relevant.
comes into question, such statements are relevant.
Whether the person who made them was or not at a time when they were made under expectation of death.
So that time when the control was made, she was not under the
Yes.
expectation of.
No, that's why will still it is covered. Because you see, I am giving a circumstances, I am giving a statement. She may be or may not be anticipating her death.
Okay, last line may be covered.
No,
Last
there
line may cover.
are a lot of decision on that.
Yes,
You see, let me tell you one thing. An example. X is found dead on the road. Before going, he told his mother that X has called me, I am going to meet X, he is standing below, and goes with X. Mother has not seen X. And then after some time, after 2 minutes, he is dead. Last scene theory,
So last scene theory, time gap has to be very short.
no, last scene theory, coupled with the fact that he gave his statement to his mother that X has called him and there he is standing down below and I am going there. So that makes a relevant statement within the meaning of section 32. One.
In this case, although she is saying these two persons are coming, although it might go against the prosecution, I must say because it's on record, right? So she is making phone call to her sister. So that two persons are coming for taking measurement of furniture. But you know whether those two persons came or not, but it's a relevant fact, your lordship, because the mobile phone was recovered from their possession. That's a link, my lord.
And PW6 has seen.
On the CDR was not safe, my lord. This goes against the
There are so many judgment options which say that the investigation, locuna investigation will not.
from like to how
There are so many judgments. It says that there is suppose some lapses in the part of the IO investigation. That will not throw away the prosecution case.
that is true, but appeal against technical double production.
CDR is not a conclusive evidence. Somebody may use my phone.
This
make a phone call.
thing will go against the appellant because your lordship goes how did it come into the possession of the accused person?
Protection was even.
You can cease to only when you are saying possession and
But there is
not.
the action made with the other Caesar.
We have got nothing to do with the Nokia mobile phone. We have to do with the Samsung mobile phone.
Just let him complete, otherwise we are not going anywhere.
When lordship come to the deposition of other deposition matter, there is a television conversation usually what happened between the family members. The PW1 who stated that matter.
Yes, please continue.
Yes, madam. I do not know the incident. Last part, my lord, one in his close he said that in my knowledge, one carpenter was working in a house. I do not know about any land dispute because dispute of the land's already been settled.
No, that's somebody else said. Pedometer 2-3, someone has said he was making a bookshelf with a
Yes,
carpenter
ma'am.
on the previous night.
Yes, ma'am.
Those evidence are there.
Even though when there is a proof, it was asked that matter. Is there any reviews were found about the meeting of this portion? They were in the room. Then my lord, PW3 also said that I know that one carpenter was working in a house. Never there, just said the two carpenters. Some later on the some are implicated, my lord, because my lord, just what happened, my lord, it was even my lord, before the trial in the court, my lord, there was media trial also going on. The media trial also going on, my lord, in that live television, my lord. Those reasons, my lord, some twist was there in that evidence, my lord. When my several witnesses said that I will come, will show the news from the TV and come to that from the TV. When my PW 7 members, yes, 21. On the same day, the evening hours, I saw that TV news in the news channel. Police got the King Raju Ali and the Nur Islam in connection of this case. Do I email numbers from the one show condition? Although do they are mentioned.
Page 45. I was telling you that thin boy. Page 45. Cross examination is coming. I saw a tall, thin boy, male, going out of the Viva Devi's house. Police did not take me to identify the accused. Police interrogated my husband. Page 48. So one person she saw.
Even my lord, there is usually one person come, my lord, at the night, my lord. We usually drop the disease, my lord, at the night.
Lordship is absolutely
Hmm.
correct. Because the time lordship matches. Around 5:30 p.m. on the previous day of the incident, I saw a tall thin boy. Previous day means they are talking of 70. Is written on 70. And the time also there. I have kept 5:30. It is there in the FIR also. That statement corroborates that.
But who is that person is not identified.
No, yes, cannot be lordship. So some stranger comes to my house, and even
No,
And
that goes against the prosecution. That means you are a victim of it.
absolutely, I'm not saying that. But okay, my submission some lapses here and there, whether it will cover the entire prosecution. Because what my brother is saying, suppose a person, it's a colony net, like a visual, it's a official colony. Suppose one person is habitually going there and knocking somebody, he will know. If the driver is there. He could not identify because he is stranger. Lone person who came on that day itself. Your presence cannot be just foreign.
Okay, that's all. I think your part is over.
Can I give my part on the paper to clear that I have noted from them? I will give my part on Tuesday, let him locate the submission.
You want a paper? उसके बाद paper. You want a paper? No, I don't read at home.
Can I carry your notion?
You may take this paper book. You can bring it on the next day. You can be sure till these 3-4 days I will not be studying that paper book at home.
Question now that is, who is putting on to me is whether his statement is just to the extent to which I am subject. That I will tell you.
Lordship, section 30. Should I read it, Madam? Here, read it. Consideration of true confession affecting person making it and others jointly under trial for the same offense. Here in this case, your Lordship, charge was my lord. Charge was framed against Nurul Islam on 15/9/2010. Prior to that, on Lordship 2810.
You see, the principle would be what I was telling him is a reverse to you. You see, the principle would be that if a person is making a statement
Yes.
who is not being tried in the same offense,
Yes.
then that would be admissible
Yes.
because he's not in the stand of the statement is neither a confession,
Yes.
he's not inculpating him.
Yes.
So therefore, it's not a confession,
Yes.
which has to be seen in the context of
With this.
the statement against a co-accused.
Yes.
The
So he
parameters
is
are
not
different.
the accused here because he is.
No,
maybe
two
tried-
things. He is not an accused in the same trial.
Yes, same trial.
He's an accused, but not an accused in the same
Same
trial.
trial.
Second part is that he does not confess anything. So that therefore it is not an inculpatory statement. Therefore it is not a confession.
Yes.
So
So
now,
Lordship, yes, so Lordship knows that there are two parts in maybe confession, exculpatory, inculpatory. Section 27, my lord. So exculpatory would be admissible. Inculpatory would not be admissible. But in this 164 statement made by the accused person, it's not under the proper procedural law as admissible by the High Court rules. My lord.
we are not saying committing anything. That's from Mr.
What shall I
Bhattacharya.
go through it, my lord, if I can find the materials in the sacred
Because this statement is otherwise the argument of Mr. Bhattacharya is this statement is otherwise admissible against the respond number 2. That is his argument in short.
My lord, my lord.
I submission.
I have read it mistakenly. 364. Examination of it. The disclosure statement was also notion of two conduct.
Evidence. My sister has pointed out she's going to the evidence. PW 19 has also stated about the cross just before the cross examination.
Yeah, this is still moving.
Lordship fifth line. Raju Carpenter along with another person would come to her house. Lordship, whether in 313 any question was posed by that he was an associate of Raju or else.
No, that's what Mr. Bhattacharya is trying to make out. He says the witnesses have said that one person was there.
Yes.
So if one person is there, and if the that accused gives a statement that it was Nurul Islam,
Yes. No
then he
POV,
says that
yes.
that is how it is integrated. That is his case.
Yes. Lordship, question number 1 in 313, it was put to him. It is alleged against you that on 17/4/2010, you and accused Julhas and Raju Ali together went to Bibhadevi's quarter, number D3 of Cotton College, and snatched a mobile phone and killed her by causing severe injury was also. That is the first statement.
Yeah, right.
Question number 2 also regarding the recovery. So he denies. Answer to Lordship at page 95. I am a rickshaw puller, I am not a carpenter. So he can be a helper, my lord.
Because his profession is not the subject matter of inquiry. So therefore, we will not enter into that.
Lordship. Lordship, evidence of PW 23.
Yes. Just tell me what is that?
Lordship, I have at page 66, I have a sports article shop at Beeborough Road. The name of the shop is Great Eastern Sports. There's a furniture shop by the name of Protege Indian Autobi on the first floor over my shop. 2 days after the date of Vibha Devi was a professor of Cotton College. Police called me to the first floor over my shop. Police told me that a boy working in Protege India Autobi was involved in the Bihari murder case. Police told me the names of 2 boys. One was Nur Islam and the other was some Ali. The boy Ali by title had worked in that shop. So it's their emotion. He worked there as a salesman. Police seized a mobile phone and a pair of sandals from that boy and asked me to be a Caesar witness. Then I put my signature as witness. It was a Samsung mobile. The brand name Kito was written on the sandal. Material exhibit is a said sandal so and so. And cross on that day, accused Nurul Islam was not there. I do not know accused Nurul Islam. I do not know about his occupation. I do not know whether police had arrested Nurul Islam or not later. I saw the materials kept on the table by the police. I do not know the model of material exhibit, but I only knew the brand of Samsung. There are varieties of size of Kito sandal. I do not know the size of this sandal. I do not even know when I read the newspaper. It is actually from the medium build person with dark complexion. At the time of seizing the material, accused Raju was standing very close to the sales counter of the first floor. So he was very much there in the shop, my lord. He walks there. It's being a lordship, the furniture shop. Oh, but no, Raju Ali has been declared as juvenile, right? Nurul Islam, it's a question to Nurul Islam, yes. Who accused Raju Ali declared juvenile, Nurul Islam, he is the accused out here, yes, he is facing the trial, he faced the trial.
Subsequent. Probably notice applicant also statement. One written statement before me becomes initial because stated that accused doing that will be necessary. One written statement before me becomes initial because stated that the accused doing that will be necessary.
Okay. We got whatever material you want. We got whatever material we want. Now you complete your argument on Tuesday.
Yes, I'll go through the entire evidence.
But Mr. A. Bhattacharya, counsel for the petitioner, sorry, appellant. His argument is concluded, reserving right to reply. The submissions of Mr. K. M. Hassan, counsel for the respondent number 2, is concluded. The Bhuya senior counsel, an additional review for the state, assisted by Ms. P. Bara, has submitted that she does not have the paperwork of the appeal. Court copy of the paperwork has been provided to her. She prays for permitting her to make her submissions on 29/8/2023. There is a list on 29/8/2023 as part of part of it. We have affirmed the judgment of the trial court. Item number. I'm sorry. Here also we have affirmed the judgment of the trial court. without finding any ground to interfere with the impugned judgment. I hope you heard me.
Only I was not there.
No, you
Not
heard me
sure what-
today. Okay, your speaker was not on. I affirm the judgment of the trial court and without interference. The judgment is
Item number 2,
the same. The judgment of the trial court is affirmed. Go ahead, Mr. Das. Mr. Reddy, you can put it. In both the judgments, I am passing with authority of the brother judge. He's authorized me because he is traveling. We both signed it.